Good morning, Judge Kelly. We do
Good
have
morning.
everybody, we have both of the attorneys present,
Okay,
as well as the court reporter.
all right. I think we can bring them all in then and begin.
The court reporter is present, but her video is off.
Okay. Can the court reporter just state his or her name?
Yes, my name is Bonnie Rosema.
Okay, Bonnie. If anything, if you've done these Zoom things, I imagine you have. If anything pops up, just feel free to interrupt and say you need clarification or you can't hear or whatever. And I know sometimes there are technical issues on this Zoom stuff, so feel free to jump right in if you need to. Okay. And yeah, there we go. Great. Oh, I had the wrong button. I hope you guys weren't waiting there too long. I apologize for that. I was waiting for everyone to appear. I'm the one not hitting the right buttons. Can you hear me okay?
Yes, Your Honor.
Okay. All right. Well, let me call the case. This is the date and time set for the trial of Susan Mickels versus the Michigan Department of Transportation. We're in the Court of Claims. It is March 30th, 2021. The docket number is 18-000159. M as in Michael, D as in David. You gentlemen want to put in your appearances?
Yes, Your Honor. Jim Iafredi appearing on behalf of the plaintiff, Susan Mickels.
Okay.
Good morning, Your Honor. Matt Reddick on behalf of the defendant, Michigan Department of Transportation.
Okay. Now, just a couple of matters before we begin. Yesterday, I received a text or something from the two of you asking about opening statements, closing arguments. I assume things haven't changed since that joint pretrial statement. I mean, you laid out your positions in that, correct?
Yes, Your Honor.
I don't see this isn't a real complicated matter. I mean, if you insist on opening statements, I'm happy to hear them, but I don't know that they're really necessary. Do you have a position on that?
Your Honor, I was thinking it would be wise we really don't need opening statements. The issues are outlined in the pretrial order. I was thinking maybe a short summation at the end, just if the court had questions and just kind of, outlining our positions possibly.
Okay. And you have filed stipulations, but why don't we just, for the record, clearly say what's going on here. I mean, the only live witness today is Mrs. Mickels?
Your Honor, Ms. Mickels, and then I had her husband just very briefly also as a witness.
And he's not a party in the Court of Claims, but he's a damage witness, and he also inspected the scene, if I recall.
Right.
Okay. And you have stipulated to allow me to read, which I have already done, all of the deposition testimony that's been submitted, including yesterday the expert, was it a SIF?
Yes, Your Honor.
Okay. As well as if the exhibits are stipulated to as well?
That's correct, Your Honor.
Okay. All right. Anything else you need to put on the record before we begin?
I don't believe so, Your Honor. I think we've really been able to kind of consolidate all the issues and present it to the court in a way that'll be really efficient.
Okay.
Yeah. As long as all of the deposition transcripts that we submitted and the exhibits that each party submitted are already in the record, then I have no further procedural issues.
Okay. All right. Well, then let's begin. Do you want to bring in Morgan, Miss Mickels then?
Where'd it go? Okay.
Morning. Are you Susan Mickels?
Yes, I am.
All right. This is kind of an unorthodox way to have a trial, but it's the way things are being done these days. So
Yeah.
you're lucky in one sense. It looks like you're at home. So not too many people can say in the history of law that they testify from their house, but these days it's getting to be pretty normal. So we're going to treat it just like you're in court. So can you raise your right hand? I'm going to swear you in. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. And I've asked the court reporter to speak up if there's any issues and not hearing you. So if you hear sort of a voice from the shadows, it will be her asking you to repeat something, or any one of us, because sometimes on this Zoom, I don't know if you've done it for, family matters, and that that there people vanish into thin air and freeze up and all that stuff. And that happens in the court system too. So with that, we'll begin. Want to start, Mr. Efrati?
Thank you, Your Honor.
Yes.
Ms. Mickels, I wanted to first give the court a little bit of background information about you, just like I would in any case. So first, could you tell the court your name and where you reside?
Susan Mickels, Groseal, Michigan,
And how long have you lived in Groseal?
since 1989.
And who do you live there with?
My husband, Douglas Mickels,
And how long have you been married?
20 years.
And what's your date of birth?
November 5th, 1962.
And how old does that make you?
58.
Could you tell the court a little bit about your educational background?
I graduated from Allen Park High School, went to University of Michigan, Dearborn, Henry Ford Community College, Wayne County Community College.
And are you employed?
Yes,
Where are you employed?
the Detroit Free Press.
And how long have you been employed at the Detroit Free Press?
30. I started my 37th year in February.
And do you have retirement in the horizon?
I hope to.
And in what capacity do you work at the Detroit Free Press?
I am a reporter and food writer.
And you go by your name, Susan Mickels?
No, I do not. I go by Susan Salaski as my byline.
And what are your responsibilities at the Free Press? Like, what is your work like in terms of how you have to function to do your job?
I, write stories, interview subjects. My beat is the food beat. So I write, food stories about grocery stores, stories about interesting people.
And how would you actually normally get to work?
I would normally, you mean?
Back at the time of the accident.
Okay, I would normally ride in with my husband and then take the bus home.
And where does your husband work?
He worked at WDIV Channel 4.
So that's in Detroit, Michigan?
In Detroit, yes.
And you work in Detroit?
Yes.
And what was the location of your work?
160 West Fort Street, between Griswold and Shelby.
You said that you would normally take the bus home. Is that your testimony?
Yes, yes.
And what bus is that?
That is the 8:30 Park and Ride.
And the 8:30 Park and Ride, would you get it from Detroit and then it would take you where?
It would get it in Detroit and it would take me downriver to usually Riverview.
And then would your husband pick you up from there?
Yes.
So let's go to the date of this incident, which September 16, 2016, correct?
Correct.
And about what time did you actually get on the bus?
It was a few minutes before 5 o'clock.
So end of the workday?
End of the workday.
What day of the week was it?
Friday.
What was the weather like that day?
Sunny.
Normal day?
It was light out, normal day.
And where did you sit on the bus?
I sat in the back of the bus, the back right seat,
Is that where you,
far back. Mhm.
was that where you normally sit in the bus?
I sit all over the bus.
And in what direction would you have been heading then before this incident occurred?
Can you repeat that, please?
What direction? Are you good with east, west, south, north, or not?
I would have been going, when I boarded the bus, I would have been heading south on Fort Street.
Okay, and at some point, would you have been heading west on Michigan Ave?
Yes.
And why don't you tell the judge what happened? The judge has already read the depositions and whatnot, so he has a good sense of what happened in the case. But from your perspective, I know you were in the back of the bus. Could you tell him what you remember about this incident?
Yes. I was, sitting on the bus, probably like reading or, normally reading, just, riding along. And then all of a sudden, when we were on Michigan Avenue, the bus hit some pavement, and the bus went down, and I flew up out of my seat, hit my head, came back down, and was in immediate horrible pain and shock and hurt, scared.
And did you have someone next to you that came to your assistance?
Yes, it was Brian Farmer.
Did you know Mr. Farmer at the time of this incident?
No.
And then what did he do for you?
He looked at me and he said, "My name is Brian Farmer." I was a medic. I don't recall exactly, but it was some military. He said, "How can I help you and what do you need?"
Okay, and did he help you?
Yes, he did.
And did the bus driver stop the bus?
He went up and talked to the bus driver for me.
And at some point, did you receive medical assistance?
I did.
And did an ambulance show up?
Yes.
And did they take you to a hospital?
Yes, they did.
And where did they take you?
Detroit Receiving.
And what part of your back was injured?
It was my lower back.
And could you tell the court what you were feeling in your low back?
It was just immediate pain, and it was just so painful. It was horrible pain. It actually radiated my entire back, and it was just. I remember just holding onto my back and thinking, "Oh my God."
Okay. And then were you seen at the hospitals?
Yes, at
And
Detroit Receiving.
were you evaluated there?
Yes, I was.
And did they do x-rays and diagnostic scans?
Yes.
And did you learn that your back had been injured?
Yes, I did.
And what's your understanding of the nature of your injury that occurred on that day?
That I fractured my back, in essence, almost broke my back, and have a compression. I lost 33, more than a third of, there's a third deformity, more than a third compression in the L2.
And that's your low back, is that correct?
That's correct.
Did you receive treatment after your injury?
Yes.
What was the nature of the treatment that you received?
I first I was advised to see my primary care physician first. And that's what I did after the accident.
And then at some point, did you receive some type of therapy?
I did. And I saw a orthopedic doctor and got physical therapy.
And was a physical therapy for your low back?
Yes, it was.
And where did you do the physical therapy at?
In Henry Ford Wyandotte.
And
Henry Ford Rehab, Wyandotte.
did you also see an orthopedic surgeon regarding consultation to see if you were a surgical candidate?
Yes, I did.
And were you a surgical candidate?
No, I was not.
Did you actually have other treatment, medical treatment besides the physical therapy?
Um, I had treatment from a pain specialist
And where was the pain specialist located?
in Dearborn. Henry Ford Dearborn.
And what was the nature of the treatment that you received in the pain clinic?
They ordered a TENS unit. They helped me learn how to manage it with different medications.
What kind of medications?
The muscle relaxers, they're prescription medications. There's two. One is a muscle relaxer. The other one is diclofenac. That is another type of anti-inflammatory.
And do you still take those medications today?
I do.
And who prescribes them?
My primary care physician,
And what's his name?
Dr. Badri Gupta.
Do you still use the TENS unit today?
Yes, I do.
Why do you use a TENS unit?
It helps alleviate, some of the, the pain that I have.
You said that you've treated in a pain clinic, you had physical therapy. What other treatment, if any, have you had since the accident? Mind you, the court has your medical records. We provided them as exhibits. So,
Right.
we don't get into all the details. They're there for the court. But has there been additional treatment?
I've been treated for, I treated with meds. I've seen the pain specialist, the back, Dr. Bartol, Dr. Evans, did physical therapy.
And did you have any problems with your low back before this incident occurred?
No, I did not.
Were you taking anti-inflammatories for your low back or pain medications
Before the accident?
before the accident?
No.
I want you to tell the court about the activities you enjoyed before this incident and whether or not this incident had any effect on those activities.
I had an active lifestyle. I golfed. I power walked. I rode my bike. I was active, physically active in anything I do. And I golfed a lot.
Were you actually involved in any golf leagues?
Yes, I was on a ladies league, and I was also asked to sub on another ladies league periodically.
So what was the frequency of your golfing before this incident?
3 times a week. Because I would golf with my husband.
So your husband's a golfer too?
Yes.
Okay. What about, I know just from talking to you, what about bowling?
We were both, that was another activity my husband and I did together with friends. And we were on a bowling league every other week. And that was something that we enjoyed together. And we no longer do that.
What about the golfing? Have you tried golfing since this incident?
Not at a course. I've tried to swing the club, but it's not possible.
Why is it not possible?
Because it's painful. It hurts. It's the movement, the motion.
Are there any other activities that you are unable to perform as a result of your injury?
I don't ride my bike. if I hit something, it's jarring. My husband does all the heavy lifting around the house for me.
So has the nature of the household responsibilities, is it in any way different as a result of your injuries?
Yes.
And how is it?
My husband, Doug, does just, like I said, all the heavy lifting, you know, and the outside work too.
When you mean outside work, what are we talking about?
Gardening, you know, I always had an herb garden, and you know, he does all the planting and everything.
Do you still have a garden?
Yeah, he does it for me.
Has the nature of your relationship with your husband changed as a result of this injury?
Yes.
And in what way has it changed? You guys, are you unable to do things like you used to, or?
Right. Well, you know, we don't golf together anymore. We don't bowl. We don't ride our bikes. We're not as intimate as we used to be. And
Okay. So if you had to, you know, explain to the court how this injury has affected your life, what would you tell the judge? I mean, just in terms of the nature of the injury and how it's affected your life and how your life is different as a result of the injury.
it is with me every day. Every day it is with me. It impacts, you know, sometimes it impacts the way I get in and out of a car. Everything, any kind of movement is just well thought out, calculated. How am I going to grab this and pick it up, and what am I going to hold on to when I try to get back up? And you know, I hold on to Doug a lot. If we're, you know, somewhere, I just grab his arm and he helps me. You know, it's just well thought out. It's on my mind always, because I have to think about things. I have to think about how I'm going to grab something. You know, if you know, it's any kind of movement. So just anything that I do, it's always on my mind. It's always there. And, you know, just, you know, thinking about it constantly. You know, if there is something that I'm going to grab, it's how do I do it? I mean, I still hold on to the bathroom door handle when I get dressed in the morning. I sit down to put my socks on.
And has there been improvement in the condition of your back?
Not really. No. It's the same.
All right. Is there anything else you want to tell the court about your injuries?
I mean, even standing up, I've been doing during the pandemic jigsaw puzzles, and even, you know, standing over a puzzle can be hard.
Okay. Thank you, Ms. Mickels. The other attorney's going to have some questions for you.
Okay, thank you.
Good morning, Mrs. Nichols. How are you?
Good morning.
Can you hear me okay? Can you hear me okay?
Yes, I can.
Okay, sorry. As far as your treatment, you indicate that your primary care doctor is Dr. Gupta.
Mm-hmm. Yes, Dr. Gupta.
Okay. And you last saw him December 23rd of last year?
Of 2020, yes.
And that was for an annual physical?
That's correct.
Prior to that, you saw him on January 16th of that year, 2020?
Yes.
And that was also for an annual physical?
Correct.
You're not actively treating with anyone other than Dr. Gupta for this condition, are you?
Right now, no.
You mentioned you had some physical therapy, I think at Henry Ford.
That's correct.
Was that in the summer of 2017?
That's correct.
And I believe you prior testified that you had between 12 to 13 sessions of physical therapy.
Yes.
Have you had any physical therapy since 2017?
No, I have not.
Have you ever been prescribed a back brace because of this incident?
No, I have not.
And you haven't been prescribed a cane or a walker, right?
No,
You didn't lose consciousness, did you?
no,
All right. You previously testified that you did not suffer any headaches from this incident, right?
I didn't suffer any, excuse me, I didn't hear you.
Headaches?
Um, n- the day of, do you mean? I mean, my back was, I was in pain that day, that my pain was,
No, I'm sorry. I'm talking about after the day of the incident.
I've had headaches now and then, yes.
Do you recall previously testifying that you did not have any headaches?
I mean, headaches in general, or
Headaches. I'm sorry. Headaches from this incident.
I don't recall.
You haven't treated with a psychiatrist or a psychologist because of this incident, have you?
No, I've not.
You missed some work because of this incident. Is that correct?
That is correct.
You previously testified you took 5 sick days that first week.
Yes, yes.
And then I believe you had, was it 1 or 2 weeks off of work after that?
3, I believe.
Okay. And were you paid, and that was, you were working at the Free Press as well at that time, right?
That's correct.
And were you paid disability from your employer for your salary for the missed time of work?
Yes, I was on sick leave.
Okay. Are you currently working in the same position you were at the time of the incident?
Yes, I am a reporter, still a reporter.
Are you
Food
working
writer.
in any formal work restrictions?
I'm sorry?
Do you have any formal work restrictions that have been prescribed by a doctor?
No, I mean,
Okay. As far as you know, all of your medical bills have been paid by either your health insurance company or auto insurance?
that's correct.
Now, going back to the day of this incident, you weren't wearing any seatbelts on this bus, right?
No,
Okay. And is it fair to say you weren't really paying attention to the surroundings as far as where this bus was going at that time?
I was probably reading.
Right. So in other words, you weren't paying attention to the construction work that was going on,
No,
and you're not aware of you weren't aware of the nature at the time of what kind of construction work was going on.
no,
You don't recall seeing any barrels or construction signs or anything that stuck out?
no.
And you didn't actually see the pavement that the bus went over that caused you to jump up. Is that fair?
Yeah, I felt it.
You
No,
felt-
yeah.
Okay. And I understand your husband went to the scene at some point after this incident. Is that right?
Yes,
And you did not accompany him when he made that visit.
no, no.
Okay. You would agree that the bus driver was going too fast at the time of this incident?
I believe that for the road conditions.
Right. And you filed a lawsuit against Smart, the bus company, right?
That's correct.
And you filed that lawsuit because you believe that the bus driver was negligent in operating the vehicle that day?
I believe she has some responsibility.
And do you know how fast she was traveling at the time of the incident?
The exact, no,
Okay. And at the time, did you know what the speed limit was on that section of the roadway?
I did not.
You previously testified that you could not feel the bus driver slowing down or applying the brake before this incident. Is that correct?
The bus was moving.
Right. And you didn't feel the bus decelerating or slowing down at any point immediately before you went up in the air?
No,
You never
I
physically...
mean, excuse me, can I go back? Did you say I didn't? Can you repeat that again? Your question?
Sure. You never felt the bus driver apply the slow down or apply the brake before this, immediately before this impact?
Right, I did not. You're right.
Okay. In other words, you felt there's no change in speed as far as what you could feel. Is that fair?
Yes,
Now, you never went back and actually measured this depression in the roadway that you talked about previously, right?
no,
And you would agree with me that this incident could have been prevented if the bus driver had been going slower.
yes. I mean, well, yes,
I'm not asking you how slow. I'm just at some point, if the bus driver was going slow, you would agree with me that this incident may not have occurred.
correct. Excuse me.
Okay, that's all I have for you, ma'am. Thank you.
Thank you.
Redirect.
Yes, Your Honor. Ms. Mickels, you were asked about seatbelts. Are there any seatbelts on that bus to wear?
No,
And I know that you've actually taken that route home, according to your testimony before the date of this incident. In the years that you've taken that bus home, have you ever had an occasion where you've been thrown up in the air and actually struck your head on the top of the bus?
no,
Anything even close to that?
nothing, never.
And do you know if the bus driver was actually traveling less than the posted speed limit?
I do not know that. I couldn't see the speedometer.
And so you don't know if she was actually traveling lower than the posted speed limit when this incident happened.
I don't know.
And then how has the injury actually affected your ability to do your job at work?
Well, I go to work every day. At first I didn't go to work every day because of it. I just don't do things like I used to. Standing a lot. Out report. I mean, I do the best I can out reporting.
Has the Free Press had any problem with you actually doing things a little differently?
No, they have not.
Does your job give you flexibility in terms of how you do it?
Usually. Like, can you define what you, flexibility, like? do
Well,
you-
like, let's say, you're not feeling good because of your back one day, and so you want to, not, do a certain type of research or something, or you need to rest. Or do you have that kind of flexibility in your job?
Yes,
And it's generally what I would call a sedentary job. You don't need to be out, doing physical labor or something like that.
that is correct.
Those are all the follow-up questions I had, Your Honor.
Okay. Thank you very much. We'll call the next witness. Thank you, Mrs. Mickels.
Thank you.
So at this time, Your Honor, we called Doug Mickels.
Oh. You want to switch chairs?
They just switch chairs there.
Oh, okay.
If
I
Mrs.
didn't see you there, Mr. Mickels.
That's all right. Thank you.
You're welcome.
Good morning.
Morning, Mr. Mickels, I'm going to swear you in. Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay,
Mr. Mickels, you were present in the room with your wife, and you were able to hear her testimony about her injury and how it's affected her life. Is that correct?
Yes.
And in terms of your observations of how the injury has affected her life, would you like to provide any additional information for the court to consider in this case?
Sure. We're in our 21st year of being married. We've been together for 33. It's been just a great, loving partnership, very strong, very powerful. We do a lot of things together, constantly, a lot of laughs, a lot of family commitments and everything else. But within this last 5 years, it has changed a bit of our everyday routines and everything else. And the emotional and everything else is there, but the physical part has left, as in happiness. But we still are a great couple.
Okay, I'm glad to hear that. And how has the nature of your life together changed from your observations?
Well, it's to be honest, it's we used to do a lot of things together, but we're doing more things together. Like I'm going out shopping more and doing things from gardening. We always do big gardening. The whole front of our home is all glass. It's an atrium, and we garden even through the winter. So.
And is Sue able to participate like she did before this incident occurred?
No, not really. No. Sue does all the mid height cleaning and that, and I do the high and low cleaning and that, from vacuum cleaning to high and low dusting to whatever.
Did you two used to golf together before this incident occurred?
Yes, at least once a week on the weekends.
And do you golf together anymore?
No, none. I've had her in the backyard trying to swing, but it basically turns out to be just a 3/4 swing, 3/4 back and 3/4 forward. So there is no power in. We weren't practicing with a ball or anything. We were just trying to see what kind of movement we could get with a golf club, but it's just not there.
What about bowling? Did you guys golf together in a bowling league before this incident?
Every other week with our friends, and that was a great time. But that probably can't even lift the ball. We haven't even tried that.
All right.
From bending over to lifting is impossible
For her?
for her. Yeah.
Did she have problems with her low back before this incident?
No, not at all. She's a better bowler than I am.
Was that before?
Before, yes.
How else has this injury to Sue actually affected your relationship together?
It's To be honest, the emotional part is there, but the intimacy is not there.
So that's something that has changed.
That has totally changed. Yeah. The romance is there, but
I get it.
the practical part's not.
All right. Now, after this incident occurred, you went to the scene and you took some photographs. Is that correct?
Yeah, a few days after the accident happened, after I finally got the explanation from Sue of where it happened, what, in that. And I was in disbelief of what really happened. Like, how can someone on a bus fracture the back in the L2 compression?
And so you went out to the accident scene and took photographs?
Yes, I did.
This incident happened on a Friday. Did you take photographs on multiple days?
Yes, I did. Probably starting from possibly Sunday through
Through,
to for a week. Because in the mornings I would drive in, and I normally don't use Michigan Avenue only because of the construction on it. I would bring 75 in and get off at Clark and go up to Fort Street and then bring Fort Street into Channel 4.
all right. And we marked as exhibits. I know you took a lot of photographs, but a lot of them actually didn't even have to do with the area where this happened. Is that correct?
Correct. I did the whole area from the scene of the accident all the way out past Trumbull on Michigan.
Okay. And so we didn't want to provide the court with those photographs because they're not of where this happened. So originally, did you have some difficulty knowing where it actually had happened?
Yes, until I showed her the pictures of what I had taken, and then and she was telling me, no, this isn't where it happened. This is where the bus stopped, and whatever. So then I would go back and take more pictures.
All right. And so in Exhibit 1, which has been provided to the court and the attorneys, there's a photograph of the area where this occurred. That's 1 of 6 and 2 of 6. That's a photograph that you took?
Yes,
And is that the general location of where this incident occurred? Now, I understand you weren't on the bus, but is that your understanding?
correct.
And in that photograph, did you make some observations of some tire marks in the actual gravel and area that's been removed?
Yeah, if you look at it, it shows like there is no vehicle tire marks that has gone through that picture. What those tire marks are from is a front end loader or some construction grade unit that they have backfilled in to correct the problem, cover the incline of what caused the accident.
Just for my clarification, we're still talking about photos 1 and 2?
Yes.
Okay.
And it's plain and see that it's fresh gravel, construction grade gravel, and then around the manhole it shows fresh dirt that is still not leveled.
Do you have, can you tell the court exactly when you took this photograph? I know it was afterwards, obviously, but do you know when this was?
It was 2 or 3 days after the 16th.
Okay. And then you took additional photographs, which are 3 of 6 and 4 of 6.
One moment, please.
This is
3, yes. That's the speed limit sign you're referring to?
Yeah.
Yes.
Is that the speed limit sign that was there if you were actually heading
Westbound.
right before the incident occurred?
Mm-hmm.
That yes?
Yes.
And then you took photograph 4 of 6 at some point of the same area?
Correct. Yeah, that was a few more days afterwards.
And then photographs 5 of 6 and 6 of 6. This is after it was repaved. Is that correct?
Correct. There it is there. Yep. Yes.
And then did you make any personal observations of the area where this incident occurred in terms of the actual area before the where the pavement was removed to the area where there was existing pavement?
Yeah, there was quite a decline or a dip when you entered the section of the cross streets. And then when you entered back up on the cobblestone pavers, it was a steep incline coming up, which obviously acted as a springboard effect in the back of that bus.
You didn't, I know you didn't make actual measurements. Is that true?
No, I did not.
Those are all the questions I have, Your Honor.
Just for my clarification, photograph 4, is that the back end of, or if we look at like say number 2, is that one end of this site, and then 4 is the other end?
That is the up part of going westward from downtown Detroit.
Which one?
4.
Okay.
Oh.
That's, I'm sorry, go ahead.
I was just going to say 4 and 1 and 2 are actually, that's the same area.
Correct.
After the incident. They're
Correct.
taking different days.
Yeah, different days. Correct.
Okay, but I mean, we look at, what was it? 6 shows the area in question after it's been repaved or re-asphalted, right?
Correct.
So 4 is one end of this site and 2 is the other end? Because like, for instance, the car wash, you don't see that in number 4.
No, go back up. That picture, what number is it? 3. No, this one's 3. Isn't it? Oh, okay, 4 of 6. Yeah, I'm sorry, 4 of 6. I would be standing on the car wash side.
Okay,
I shot that out of the window of the car, to be honest.
all right, I got it. Okay. And Mr. Mickels, did you go, I mean, you went from one side of the street to the other. Were you actually like in the area where this happened, or were you only on, the
No,
sides of the street from where the photos were taken?
1 and 2, I got out of the car and shot towards the car wash. The next ones are all from my vehicle, all the way to 6.
No.
Okay, all right, thank you.
No, that's,
Oh,
there's
okay.
the arm of the car right there. Yeah. So the first 2 are, I got out of the car and I parked on 6th Avenue. And the balance is out through the windows of my vehicle. As
I realize this is a bench trial and some of the rules are a little relaxed, but you probably shouldn't consult with your wife when you're testifying.
Oh, I'm sorry.
Easy thing to do. That's okay. But let's just see what you remember and
Yeah.
yeah.
Well,
Okay.
let's go back. All right. 1 is I'm out of the car shooting towards the car wash. 2, I'm out of the car shooting towards the car wash. 3, I'm driving. You can see the hood of the vehicle on the 35-mile-an-hour zone. The cutout or the dig, when they remove the gravel to get ready for paving, is out through my driver's side window as I'm going eastbound into Detroit. And the next one is the 35-mile-an-hour zone out through the front of my vehicle. And the last one is the paved section out to the vehicle. That's it.
Okay, all right, thank you. All right, those are the only questions I had. You want to continue?
Who, me?
No, your lawyer.
Oh, sorry,
Yeah.
Judge. So, Mr. Mickels, from your observations, could you definitely observe a change in elevation between the existing pavement and the removed pavement from what you personally observed?
Yes.
All right, Your Honor, those are all my questions.
Okay, thank you. Cross?
Thank you, Your Honor. Mr. Mickels, just a few questions for you. You indicated that you took picture 1 and 2 of 6, 2 or 3 days after the incident. Is that correct?
Correct.
And the incident occurred, as far as we know, on a Friday, the 16th.
Correct.
And so it's your testimony these were taken either Sunday or Monday,
Yes.
but you don't know which day.
Not read it. I'd have to review it again.
And can you tell me what time of day you took photos 1 and 2?
It would be mid-morning, 10, 11 o'clock.
Did you observe any construction activity when you took these photographs?
None at all.
And how many times were you at this scene after the 16th to take photographs?
Oh, probably between 3 and 5. I drove in that way every morning to see what the progress of the construction was doing.
And do you know when the project was completed?
Probably around the 20, maybe the 23rd or 24th.
Can you tell me what day you took photo 4?
Be one of those days. Sorry, I can't.
There's a difference between how the street is depicted in photo 4 versus photo 1, correct?
Correct.
The ramping or the milled out ramping had been removed by the time you took photograph 4. Is that correct?
Correct.
And then photograph 6 is a photograph with the pavement, the new pavement added, correct?
Yes.
And do you know what day you took this photograph?
I'd have to refer back to my my phone.
And looking at this photograph, this is the extent of the size of this project, correct? As far as you could observe?
Yes.
And it looks like there's barrels in the background and possibly other construction projects going on around this same area of roadway. Is that your understanding?
Yes.
Did you actually go in the roadway, walk out of your car and go in the roadway to take any photographs?
No, just what I shot at 1 and 2 off of 6th Avenue.
And again, you didn't take any measurements of any kind on any of these occasions. Is that correct?
I did not.
And so the extent of what you did at the scene was take photographs with your, I assume it was your phone.
Correct.
Okay. Did your wife accompany you during any of these site visits?
No.
Okay, that's all the questions I have for you, sir.
Your Honor, I
Any
have no,
redirect?
no, Your Honor.
Okay, thank you, Mr. Mickels.
Thank you.
That'll be all. Okay,
All right, thanks.
sure. All right, and that's it for our live testimony?
Yes, Your Honor.
Are you ready to do your brief closings then?
Yes, Your Honor.
All right.
Would the court like me to begin?
Yes, I'm sorry, I should have said that.
Oh, that's fine.
Okay, go right ahead.
Sure. Your Honor, first thing I wanted to talk about a little bit has to do with the non-party in the sense that there's obviously a question about the bus and whether or not the bus is partially responsible for this incident. So the bus was traveling under the posted speed limit of 35 miles per hour. And
33, right?
she was going, right, exactly. There's actually a recording from the exhibit from the video, so that she was going 33 miles per hour when this incident occurred. And there was no, obviously, this wasn't an active construction site at the time this incident occurred. However, there were barrels out and whatnot. So the issue is whether or not the bus driver should have slowed down given the conditions of the roadway. And, it's always been our position that the bus driver has, some responsibility. A bus driver should, if she's able to see that this depression was there, that she would have a responsibility to slow her bus down for that road condition. And that's always been our position. However, in this case, the defendant, Michigan Department of Transportation, did not file a notice of non-party at fault. So what the court rule states is that if they do file a notice of non-party at fault, then the court would assess their potential fault for the accident. So if they're 20% at fault, you'd assess 20% at fault as to the bus driver. If they're more than that, you make that assessment. But what the court rule says under MCR 2.112K is that if a party does not file a non-party at fault notice, then the court shall not assess the fault of the non-party. And MDOT did not do that in this case. Whereas in the case that we filed against the bus, they did in fact file a notice of non-party at fault against MDOT. So it's their position that the responsibility for this incident is MDOT and not the bus. And so it's my position that the court really shouldn't even be assessing whether or not there's some partial responsibility on the part of the bus driver because of the fact that they never filed a notice of non-party at fault. Now, in terms of the liability against the Michigan Department of Transportation, I mean, obviously, we've outlined the issues in the pretrial order. And the first issue is, was the roadway reasonably safe and convenient for public travel? I think that, frankly, the most supportive witness for the plaintiff is Brian Farmer, who's the independent witness that I videotaped for the court. So the court he was sitting right next to Mr. Mickels. He testified that as the bus is going through this area where the road was under construction, and the defect we're saying is that there should have been a taper between the existing roadway and the removed pavement, and that there wasn't an adequate taper or taper at all. And as a result, when the bus comes through, there's going to be a large impact with the front wheels and the back wheels, which propels Miss Mickels and the other passengers on the bus up in the air, causing her to strike her head, come back down, and then break her back. But this witness, Mr. Farmer, he said he had driven in the same direction more than 200 occasions, because he said that the federal government would pay for his bus ticket, but they wouldn't pay for parking. So he would use that he would actually take that bus there all the time, and he never in his years had anything like this ever occur, where people would actually be propelled up into the air and be injured like that. And it wasn't just Miss Mickels. There was there were some other passengers who were also injured as a result of this incident. But what was most compelling about his testimony is that he said that he came back out there, I believe the Monday morning around 6 a.m. and he looked at the area where this incident occurred. And his observation was that there was a 4 to 5 inch discrepancy between the removed pavement and the existing pavement. And all the testimony from all the experts in this case. So I had an expert who testified that the transition area should be, if you've got 1 inch removed, you have 5 feet of taper. If you have 2 inches, 10 feet. That was his testimony about the nature of what the taper should be. And it was his testimony that this wasn't an adequate taper, and therefore it was defective and not reasonably safe. Their expert, he says, no, you don't want to use that MDOT rule. That's from the Michigan Manual of Traffic Control. He says you don't use that because you only use it for where you're using an asphalt taper. My guy says it doesn't matter if it's asphalt or millings. That's the proper taper. It's right in the rule book. But they all agree. Their expert says that that it should be a transition that's smooth. Everyone agrees that the transition is supposed to be smooth. Their expert, the MDOT inspector, my expert, and their experts, he doesn't offer an opinion about whether or not it's smooth or not, because it's obvious it wasn't smooth. I mean, we've got a videotape of this incident occurring, and you can see that it's not smooth. And what happens is there was not this adequate ramping that existed, and as a result, this incident occurred. One of the things that we saw too is if you look at some of these photographs, that photograph taken by Mr. Mickels after this happened, you see some. It looks like they've tried to repair that. They've denied it, but it looks like there's construction markings in that area where there's, if you look, it's not car tire markings. Those are markings from vehicles. So it looks like they've came back and they added some millings and then to try to make it better in terms of that transition. But if you look at the still photographs from the bus, that's exhibit number 3, the last couple of photographs, you can see that ledge there. These are right from the bus. You can tell that it's different. It's not the same. In other words, the still photographs from the exact moment, which aren't the greatest of quality, but that's what MDOT, not MDOT, I'm sorry. That's what SMART was able to do with still photographs. And then you look at the photographs that Mr. Mickels took afterwards. They look different. So, to me, looks like someone, I don't know who, went out there and tried to make that a little better after this happened, this ramping. But so, and getting back to the issue of whether or not it was reasonably safe, I mean, a bus traveling within the posted speed limit, under the posted speed limit, without any warning signs, should not be propelling passengers up into the air, striking their head and being injured. I mean, that road was not reasonably safe at the time of this incident, and they created the hazard. MDOT had control over this roadway. They had control over the construction. They hired the contractors to do the work. And so they created a hazardous condition in the roadbed that caused this injury. That's that prong of the liability. This roadway was not reasonably safe and convenient for public travel. The other issue then becomes the notice issue. And the testimony is that, well, they created the hazard. So where they created the hazard, they're presumed to have notice because they created it. So that's notice issue is met right there when they create the issue. There wasn't an issue until they actually did this road paving project. Number two, the MDOT inspector testified that he approved the ramp. So he was there to inspect it right before they opened it up to travel. And he also said that if there was a problem, MDOT would have known about it, that this roadway was under constant surveillance, and they were out there all the time. So they should have known that this was an unsafe condition that they created. First, that, obviously that, they would have known about it because they created it. Secondly, the MDOT inspector testified, and so did the contractors, that he actually inspected it and he opened it up and he inspected the ramping. So how could they not know? I mean, if you're going to blame the bus driver for not slowing down, how can you say that the inspector shouldn't have been able to see what the problem was here? So they had either actual or constructive notice under the statute. Lastly, causation. I mean, that to me seems real clear that, it's what she was propelled into the air. It's this road defect, the road bed that caused her to go up in the air, hit her head, come back down, and break her back. So the causation element is satisfied because of the nature of how this happened. The video confirms that. The video shows her. I slowed it down at like 4:30, and you can see actually Mr. Farmer, his arms up in the air. You can see Miss Mickels going up in the air. You can see them then coming down, and then she's slumped over immediately. So this incident clearly caused her injury. So we've satisfied the three prongs of liability. The roadway wasn't reasonably safe, that they had notice or constructive notice, and that this caused her injury. So the last issue is damages. And, when it comes to damages, I mean, I always look at, when I'm assessing damages, first of all, it's past damages and then future damages. And the way I look at the issue of damages is it has to do with how interfering the injury is in someone's life. How much of an effect does this have on someone's life? And you look at that in the past and you look at that in the future, and what we're asking for obviously is compensation for these non-economic damages. So the compensation should balance the damages that were caused, the harm that was caused by the injury. And so you're looking at how this interfered with her ability to lead her normal life. And what's happened here is she has to live her life completely differently. And so she's heading into retirement with her husband, and they were very active together. They enjoyed doing, activities together in terms of whether it be bowling or whether it be golfing. These are all activities that it actually requires someone to have a healthy back. And this isn't like a normal fracture where, normally fractures, they'll heal, they'll meld together. And if you look at the testimony from our medical expert, compression fractures, they're different. So it's a permanent deformity in the vertebrae. The vertebrae is different now. It's not the same as it was. They don't heal the same way. And given the nature of the injury, it's a permanent injury. So it's not going to change, especially after 4 years. She's got to live with it. She's not a surgical candidate, and she's now going to live her life differently than she would have had this incident not occurred. And it affects, the worst part of this is it affects her relationship. I know they're a strong couple and they're going to obviously be together, but the nature of their life has been changed as a result of this injury to her back. And so they're not going to be golfing together. They're not going to be bowling together. They're not going to be doing those kind of activities that they enjoyed. And so if you find liability in this case, then you'd be looking at trying to compensate her for the harm that's caused to her life as a result of this injury. So she has a permanent injury. They have their IME that suggests that she's fine, but she's not fine. And if you look at, interestingly, the insurance company, auto owners, the PIP carrier, they did an IME about a year ago, and he confirmed, the independent doctor for the auto carrier said that, yeah, this isn't going away. It's a permanent injury. that she's going to have to basically live with. So how does she live with it? Well, now she lives her life differently. She has to be careful about how she moves. She has to be careful about not lifting too much. She has to take anti-inflammatories. She has to, take pain medications when they're necessary. So her life, her quality of life is significantly different as a result of this injury. So the court should assess what would be fair compensation, adequate compensation to balance that harm caused for her, going back in the past 4 years. And then her life expectancy, because it's a permanent injury, is 26 years. So for 26 years, the court should look at what would be reasonable compensation to balance the harm that was caused as a result of this injury. So you could do it in terms of a per diem way. You could look and you could say, all right, $1,000 a month, $12,000 a year going into the future. You could, there's a lot of different ways you could do this, but typically you do it in terms of a per diem. So, and what we're saying is this is a substantial injury that's going to affect her for the rest of her life. And she should be compensated every year into the future. And then she should be compensated for the past 4 years for what she's been through as a result of this injury. And we just ask that you do that. We think we've established liability, and we request that this court award damages that are fair under the circumstances. If in terms of a particular number for the past 4 years for the initial injury and the harm that was caused and everything, I would say that the injury for the past has a value of between $100,000 and $150,000. And then for the future, if you awarded between $10,000 and $15,000 a year for her life expectancy, I would think that that would be reasonable compensation under the circumstances of the case. And that's really all I wanted to talk about, Your Honor.
Okay, thank you. Now, Mr. Reddick?
Thank you, Your Honor. With respect to Ms. Mickels' injuries here, the court has not heard from any of her treaters. No medical treater has offered any testimony in support of the claims in this case. The only medical testimony the court has heard or will hear is the hired expert from both sides, so the hired IME doctor. Plaintiff has an IME doctor as well as defendant. The doctor that plaintiff hired conducted his IME in February of 2018. We don't have any other testimony, medical testimony, expert testimony regarding plaintiff's condition since that time. In addition, plaintiff is not actively treating. She is not treated in at least 2 years for this condition. The only medical treatment that's documented in the record are annual checkup physical appointments to her primary care physician, where this is a listed condition amongst several others involving this woman's life. In addition, she was able to regain employment, return to her job within 3 weeks of this incident, and has not had any issues working full-time without any restrictions. She has no doctor-provided prescriptions, no disability prescriptions. No doctor has restricted her physical or lifestyle activities in any way since this accident. In addition, Dr. Singer has testified that this type of compression fracture typically and usually heals within a matter of months, and that, to the extent plaintiff has complaints of injury, they are unrelated to this compression fracture, which occurred almost 5 years ago. With respect to the notice of or the fault of Smart is involved in a lawsuit that I believe was already pending at the time that this lawsuit was filed. And plaintiff, that lawsuit is still pending. where plaintiff has filed suit against Smart, claiming that they are responsible, that their driver was responsible for operating the bus in a negligent manner in this case. But really the issue boils down to a very narrow one, and that's whether this tapering and the change in elevation here is considered a defect. As the court is well aware, the highway exception to governmental immunity is narrowly construed and provides that the governmental agency shall maintain the highway in reasonable repair so that it is reasonably safe and convenient for public travel. Well, that's just what MDOT was doing in this case. They were actively repairing this portion of the roadway. This was a, excuse me, a small maintenance project at the intersection, and the court can see the extent of the work that was done based on the photographs. You know, it was only limited to this intersection at Michigan Avenue and 6th Street in downtown. So this is a small maintenance project that occurred over a period of 4 days. And so the court has to ask itself, did the legislature mean for a governmental agency to be liable for a 2-inch elevation change in a roadway that is still under construction, that still has barrels outside, that still has construction signs saying road under repair? And MDOT's answer is no, that's not what the legislature intended, and this is not an actual defect. The court previously denied MDOT's motion for summary disposition on this issue because it believed that there is a question of fact regarding what actual defect there was. If the court will recall, plaintiff's husband provided an affidavit claiming that the change in elevation was up to 8 inches. However, he did not testify to that or any other opinions of his regarding the length or the height of this elevation today. And so that's not in the record here. And what the court will see, based on all of the deposition transcripts that have been submitted, is that both experts agree that the elevation was 2 inches tall. Plaintiff's expert claims to have performed measurements at the scene, and based on photographs that were provided to him, actually the photograph from plaintiff's husband, and he admits that this elevation change was only 2 inches tall. And because of that, there's no issue here now, as opposed to at the summary disposition stage, about how high this transition was. It was only 2 inches tall, and there was a slope. Now, plaintiff's expert claims that this was improperly milled out or ramped in violation of MDOT standard specs. The problem is he relied on the wrong section of the standard specs with regard to transverse construction joints, and that has to do with once new pavement is actually added. Here, we're dealing with a very small project in which there was no added pavement. The site was still under construction. However, the roadway had been opened up after MDOT and its contractors had reviewed the area and deemed it safe for travel. So we're dealing with a 2-inch height taper here. And plaintiff's expert, as the court will see, he guesses about the length of this taper and claims that it's inadequate based on the length on the 5-to-1, that the 5-to-1 ratio that the MDOT specs provide. The problem is he's basing this really a guesstimate on the shading of the photograph, the shading of the dirt. He did not do any actual measurements at the scene. He's relying and essentially guessing on how long this taper was based on the color of the dirt that's depicted in the photographs in the record. That's an improper method. It's not scientific at all. Plaintiff's expert, Mr. Valenta, admitted he's not an expert regarding interpretation of photographs involving color shading, any of that. So both experts agree there is a taper here. Our submission is that this taper is certainly adequate. The contractors at the site testified that they had reviewed it, that it was adequate, that they did all the tapering around the exterior of the project and around the manhole covers, and that it was sufficient and that it appeared adequate. I think it's important for the court to understand that this is a isolated incident that appeared on one bus in this 4-day period. There's no other known issues of injuries or incidents from any of the vehicles that traversed this section of the roadway during that 4-day time period, including over 7 smart buses on this date of the incident, September 16th. We submitted the deposition transcript from the SMART operations coordinator who admits that they have no records of any other incidents on the SMART buses on that Friday or on either weekend day before the road was repaved the following Monday. So this was a isolated incident, and this driver should have been driving slower. A bus driver is not simply permitted to drive the speed limit because it's the posted speed limit. The driver is required to ensure the safety of her passengers by driving based on the road conditions in a safe manner. Certainly, as the court will see from the video and the photographs of the incident in question, it's clear to any driver that this was a roadway that was still in a construction zone, that was in the process of being repaired, and that a reasonable bus driver would have slowed down to a speed that would allow her to safely traverse this portion of the roadway, including a 2-inch bump with this taper here. And by the way, even assuming the plaintiff's expert is correct regarding his calculations of this taper, we're talking about a 3-degree slope, where MDOT's expert believes that is a 1% slope. 1 degree slope, and plaintiff's expert claims it is a 3-degree slope. Even a 3-degree slope and a 2-inch difference in elevation, MDOT submits that's not a defect in the roadway. The case law that we've cited and that apply to the governmental immunity section indicates that drivers should be aware of either potholes or changes in elevation in roadways and drive safely, and that the governmental agencies are not to be liable for every little pothole or elevation change on a roadway. And that includes, in this case, a mere 2-inch elevation change here. So again, this is the section is narrowly tailored. And the Supreme Court in Jones has even stated, even when a roadway is rough, that simply calls for more careful driving than on other portions of smooth roadway. And had the bus driver in this case recognized this, as all the other drivers in this that went through this intersection in that 4-day time period did, she would have gone slower and realized that that by slowing down, she could have safely traversed this section of the roadway. It's MDOT's position that a mere 2-inch elevation change in a roadway is not a defect. And again, this was a portion of the roadway that was being repaired. The intent of the legislature is for liability for governmental agencies who fail to repair roadways, who let roads degrade and disintegrate over time. MDOT was actively on a repair project in this case, and all the testimony from the contractors to MDOT supervisor, they testified that they saw the ramping, that it was sufficient, that they drove vehicles through it and made sure that it was safe before opening it up. Again, this is an isolated incident. It's and the law, the legislature did not intend that governmental agencies are required to maintain perfect roadways. They only have to be reasonably safe. And this portion of the roadway was reasonably safe for all the other drivers who went through it during that 4-day time period, and all the other buses, smart buses that went through it as well. Certainly it's reasonably safe for everyone who has a seatbelt. And while people on the smart buses don't have a seatbelt, as in this case, had the driver been operating at a safe speed and recognized that there was a unsmooth portion of the roadway ahead of her, as the other bus drivers had, then this incident would not have occurred. So that's MDOT's position, that there is no liability here, that this is an incident in which liability can only attach if the court claims that all roadways have to be maintained in perfect condition. Had the bus driver here, as all the other bus drivers and all the other drivers during this time period did, had driven at a slower rate of speed, this incident would not have happened, and the plaintiff would not have bumped up from her seat from a mere 2-inch elevation change in the roadway. So based on the highway exception to governmental immunity, MDOT asserts that this does not fit into that narrow exception, and that based on the entirety of the record, the expert depositions and the photographs and the video, the court should find that while not perfectly safe because of this incident, MDOT maintained this portion of the roadway in a reasonably safe manner, and there's no documented violations of any standards or any specs that this ramping and this elevation change violated. Thank you. That's all I have, Your Honor.
One question for you before you wrap up. Do you want to address at all the argument about the failure to file a non-party at fault against the bus driver? Because it seemed like a sizable chunk of your argument there was based upon that.
Well, certainly. I mean, obviously we're in the court of claims, and there was already a pending lawsuit against Smart, and so plaintiff cannot bring Smart into this court of claims case,
Right.
and that's what the notice of non-party fault court rule provides, an opportunity for the plaintiff to bring in a party to a lawsuit. That's the purpose of the notice of non-party at fault provision. The parties have not really briefed this issue. It's more of a legal issue, and I'd be happy to do so if the court would like us to. But I believe, and I don't have the exact timeline of when the cases were filed, but I believe there's already a pending lawsuit against Smart and against the contractors in Wayne County Circuit Court. This case obviously had to be filed in front of Your Honor in the court of claims because it was against MDOT. I don't think it prevents us from arguing that Smart is liable here, and it's not necessarily a percentage at fault or joint and several liability. I mean, MDOT's argument is that it has no liability because it was not negligent under the highway exception to governmental immunity.
Okay. All right. Thank you. Any rebuttal?
Yes, Your Honor. Just the argument about that there were no other incidents with other buses or other vehicles, that's just pure speculation.
I think he said any reported.
Okay, all right.
Which is the whole point. There could have been 100 of them and nobody bothered to call and report. Right.
I mean, there wasn't even a police report on this incident. So anyway, so I just think that part of the argument is a little speculative. With respect to the actual defect itself, again, if you look at Brian Farmer, he testified at page 12 of his deposition that, and I'll just quote it, it was a straight drop of about 4 to 6 inches. And then on the other side where the cement, the normal roadway picked up, it was 4 to 5 inches. There was no, you would think there would be some type of slope or decrease for cars to ease down, you know, an apron, if you would. And I was surprised there wasn't. So, all right. And that's what I know. And are you sure that's the area of the roadway that the bus hit that day? Answer, yes. I mean, so there's a substantial defect that they created. This roadway became unsafe as a result of what they did. This wasn't some just rough road. I mean, I drive on rough roads all the time, and you know, I've been on buses all the time. And the testimony in this case is that this incident that they created, this lack of an adequate taper, temporary taper, caused the bus to project people in the back up into the air and hit their heads. I mean, it wasn't just my client; it was you know, other passengers too. And unfortunately, when my client came down, she broke her back. So this wasn't some, you know, pothole. It wasn't some, you know, minor issue in terms of the roadway. It was a significant problem that they created. And frankly, when I look at these photographs that Mr. Mickels took, those first ones, it looks like someone came back out there and added some gravel to that area. If you compare the photographs from the bus, the stills that aren't the greatest of quality, to the photographs taken later, it looks like something was going on there. But obviously, it's I wasn't there to observe that, and I don't have any. They've denied it. So, but if you look at the photographs and the tracks, it looks like there's something changed. The other part I wanted to just talk about a little bit is the fact that there was a reference to the fact that there wasn't any testimony from the treaters. I mean, we have the records. It's really not disputed, the injury itself. What's disputed is whether it's permanent or not. I mean, if you look at the MRI, it says right on there that it's an acute injury because there's edema, so there's swelling that's picked up, and everyone agrees that this injury occurred. The question is, okay, is this something that's permanent or that should have healed? And you know, the person that I used testified that, you know, after 2 years, that the nature of this injury, that is going to be permanent. It's not going away. Well, if you look at the IME that was done by the insurance company, in this case, he agreed, and I had nothing to do with him. He was picked by Auto Owners Insurance Company to do this evaluation, and he confirmed that this was a permanent injury and it wasn't going to get better, and she's not going to go back to her prior level of function. It's at the last 2 pages of his report, and it was marked as an exhibit for this court to look at. And as for their expert, it's kind of interesting. He called him the person that he used as an expert in this case. Kind of ironic. I looked at he has a web page for the doctor's office for the IME, and it actually has a section on compression fractures. And so I asked him about it, and I marked it as an exhibit. And what it says about compression fractures is a lot different than what he said in his deposition. And I'll just leave it at that. So, you know, this wasn't just some minor issue with the road. And I don't think it matters if it's a small project or a large project. In this case, they created this hazardous condition. This bus driver, whether, you know, she has some responsibility for not slowing down. I mean, she was traveling within the posted speed limit, 33 in a 35, and when this incident occurred. And I believe it was her first route in that direction that day. That was the first time in that direction she had actually traveled on the day of this incident. And as for what the other bus drivers did, we just don't know, frankly. And the buses don't run on the weekends, so there wouldn't have been buses going through there. So I think we've satisfied our burden of proof in this case, that by preponderance of evidence that MDOT is responsible for this incident, and they're responsible for the harm that was caused to Ms. Mickels.
Okay, thank you both. a couple of questions. I mean, oftentimes in bench trials, judges ask for proposed findings of fact, conclusions of law. I don't believe I need that. Secondly, and I haven't made up my mind, so don't get nervous when I ask this, but if I do find liability, and if I do find damages, and if I do find future damages, would you want me to put it year by year, or to give a number that I find is the number reduced to present cash value for future? I mean, do you have it's usually, I mean, when I was a lawyer, it was always a lot easier to, have a number that you didn't have to tinker around with all that.
I would prefer that, Your Honor, so that, if the court did find liability and damages, that we just have one number, because otherwise we're just going to have to reduce it for present value. And so as long as we understand that that if the court did make an award and it was a single award, that it has been already reduced to present value, because you can't do it then. Obviously you can't do the calculation unless you put every year out there. So we'd have to agree to that.
So Reddy, do you have any position on that?
I don't, Your Honor, as long as it's clear if there is a damage award,
Yes.
as long as
Yeah.
the court makes clear what that would represent in the record, I have no issue either way.
Okay. All right. Well, anything else you need to put on the record, or are we?
I don't think so, Your Honor.
All right.
So the court does not need anything or want anything further from us. Is that accurate?
That's correct. If in writing an opinion, I decide I need briefing on something, I'll certainly let you know. But at this point, I think I can handle it without that.
Okay.
All right.
All right, thank you.
Thank
Your Honor,
you
for-
both very much. Okay.
Thank you, Judge.
You
Thanks
did a
for
nice job both throughout the case, and good lawyers, both of you.
Thank you.
All right, thank you. And Bonnie, do you need anything else, or you said,
Will you be needing a transcript?
do you lawyers need the transcript?
No, Your Honor.
I do not at this time, but once I start writing this, if I think I need something, I've taken pretty extensive notes. I'll let you know. But you know what? Better safe than sorry. Yes, let me order it.
Okay, when would you like it by?
Well, what's your normal time?
2 weeks.
Okay. If it could be quicker than that, that'd be great, but I can live with that.
Okay.
I always hated when I was a lawyer, I felt bad for court reporters when people didn't order the transcripts. And so I always ordered. I'm not gonna stop that tradition now. So I feel better ordering it.
Well, I'll order a copy too, Your Honor.
Okay.
Well, I don't want to be left out then.
All right. Good. We've made your day then, Bonnie. Well, thank you all
very
very
much.
much. Okay, great.
Thank you.
All right.
Okay,
Bye.
thank you.
Have a good day, everybody.
Bye-bye.